So hello and welcome to NLP's latest update on government law and policy. We're here today to talk about a brand new act that will hugely change the way that the planning system deals with historic buildings, heritage assets as we know them in the planning world. I'm Maggie Baddeley and I'm here today with Iain Rhind, one of NLP's directors, who has extensive knowledge and experience of working with historic buildings and other assets in terms of incorporating them in regeneration and other schemes, particularly for housing, cultural and other mixed uses. So, Iain, the Enterprise and Regulatory Reform Act.
Yes, well, we finally have an act. It went through Parliament on the 25th of April after a relatively quiet time. Although there was a bit of a flurry of change as a result of some late consultation by DCMS and CLG.
Taking a step back then, where do these reforms originate from?
Well, it came from the 2010 Penfold Review of Non-Planning Consents and then a subsequent review by the government in 2011 to establish how they would actually put those changes into practice. And the basis of it is to essentially try and streamline the non-planning consents, in this case heritage consents, so there's less burden on landowners and developers.
What would you say the key changes in the Act are?
Well, I think four main areas. The first concerns the removal of the need for conservation area consent. From now on, conservation area consent will be wrapped up in the grant of planning permission. And then the second area is in relation to listed building descriptions. From now on, it'll be possible to specify in a listing description where there are issues which don't actually add to the significance of the building in terms of its architectural historic significance. And I think that will have the potential to reduce the number of applications for listed building consent in the future.
I understand too that there are new statutory arrangements for heritage partnership agreements whereby listed building consent is granted for specified agreed works.
Yes, this is a combination of the heritage partnership agreements which we've had in the past, sometimes called conservation plans, and a series of class consents for works which won't require the specific grant of listed building consent. And I think together these measures will reduce the number of applications for listed building consent quite significantly, particularly in the case of complex heritage assets.
Yeah, and what about the changes to the current system of certificates of immunity?
Yes, in the future, developers and owners of buildings will be able to apply for certificates of immunity from listing at any time. At the moment, you can only apply when you've got an application in the system or when there's been a process of considering a building for listing. So I think that will be extremely useful in terms of establishing the risk of listing for owners of property in the future. And then the second area is in relation to certificates of proposed works to a listed building. It will be possible to establish whether, as a matter of law, listed building consent will be required for certain works.
I've read that the government actually thinks that these changes will all cut red tape and introduce deregulation into the heritage regime without actually removing any of the vital protection that's needed for historic buildings. Do you think that's the case?
Yes, I think so. I think taken together the measures which are being introduced are going to be helpful in reducing particularly the number of listed building applications submitted, and also it'll remove altogether duplication with conservation area consent. And we think also that the certificates of immunity proposals and the certificate of proposed lawful works will also have the potential for removing the burden on owners of listed assets without threatening any of the heritage of the nation.
So are there any potential drawbacks of the Act?
I don't think so. I think the only drawback is that there won't be any change in the foreseeable future. So as far as the need for listed building consent is concerned, where that is required, there'll still be a need for a great deal of detailed information to be prepared and submitted, and for very thorough evidence to be put forward to establish the effects of proposals on significance. And that's something that we at NLP have a great deal of experience in.
When will we see some of the changes or all of the changes coming into use?
Well, there'll be consultation on the draft regulations in the late summer and early autumn of this year. Potentially they'll come into force next April. That means there's going to be the opportunity for interested parties to participate in the consultation on those regulations, and we'll be advising our clients accordingly.
Thanks, Iain. And just to let you know, we will be reporting on the draft guidance and regulations when they're published. In the meantime, please take a look at the NLP website where you'll find details of our heritage work and also other useful planning resources. And you can always follow us on Twitter. Thank you.